Okay, what did you see that it's suspicious?
कि अगर 40 क्वेरी मेरे को अगर रन करनी है तो वो कितना टाइम लेगी ईच सर्वर।
पता नहीं, तुम्हें पता लगेगा। तो अब सुबह तो है।
Good morning, everyone. We'll be starting in the next 5 minutes as we are waiting for other partners to join the meeting. Thank you.
So they are on it. Yes.
Okay. Trupti, I need to get on another call. After that, I'll call you sometime. No?
Okay. Sir.
Okay, thank you.
Very good morning to everyone. Am I audible?
Yes,
You're audible.
Kindly respond if I'm audible.
Yeah, audible.
Okay. So we are starting with the day 2 of our session pertaining to Digital Personal Data Protection Act. And before going through, I would like to recall what we have discussed yesterday, and it was pertaining to that applicability of Data Protection Act. To what data it is applied, that is only the digital data or the data which has been later digitized. And further moving, we have discussed about the key definitions pertaining to data, digital personal data, data fiduciary, data principal, data processor. And then we have discussed about consent framework and consent manager, which is a newly introduced framework in our ecosystem, which was very deeply discussed yesterday. And moving further, we discuss about certain legitimate uses under which data can be processed without taking consent from the data principal. Further, we discussed about grounds of processing of personal data and what kind of notice is to be given to a data principal prior taking their consent for the processing of their personal data. Moving further, we discussed about general obligations of the data fiduciary, that what all they have to adhere while taking care of the processing of personal data of the data principal, and what all key points they should always consider and keep in their mind before processing the personal data of a data principal. Further, we discuss about that central government on the basis of volume, nature, and risk to electoral mandate and other certain enumerated provisions may declare a data fiduciary to be a significant data fiduciary, and what all additional compliances have to be adhered by significant data fiduciary. It was also deeply discussed yesterday. Moving further, we discuss about processing of personal data of children, and we have taken care that we may be very clear about the sensitivity of the data which is pertaining to a child. How we have to process the data of child and a person with disability. Further, today we will begin with rights and duties of data principal, and we will discuss about Data Protection Board of the India, certain exemptions given under the DPDP Act, and then we will discuss about the miscellaneous provisions, which in and out should be adhered by each and everyone in the ecosystem. And finally, we will discuss about the penalties which have been enumerated under the DPDP Act. So beginning with the rights and duties of the data principal, the first foremost right is right to access information about personal data. Now, every data principal who has given their consent for the processing of their data can always make an application or request the data fiduciary that they can have the summary of their data. They should be told about who all data fiduciaries are processing their data and what all data processors are processing that particular data on behalf of data fiduciary. They can also ask for the any other information pertaining to their
can I
data
request
and
others to go on
in a
mute,
descriptive
please?
manner from the data fiduciary.
It's a lot of
And
background noise.
or for all of this, central government will prescribe certain standards and rules which are yet to be notified. And there is one exception to this right also. If there is any data fiduciary who is lawfully authorized to ask the data from another data fiduciary for the prevention, investigation, and detection of any offense or cyber incident or prosecution of any offense, then that particular data fiduciary is exempted to exercise this particular which has been requested by the data principal from the data fiduciary. Moving further, the second right is right to correction, updation, erasure of personal data. Under this particular right, data principal can right to data fiduciary that if there is any inaccuracy if there is any content, any data provided by data principal which is misleading in nature, which is incomplete, or which is to be updated. For this all purpose, a data principal write to the data fiduciary that you may please kindly exercise all this functionality and update according to my request. And there is one particular instance under this, right, that is related to erasure. Now, if a data principal has written to data fiduciary for erasing his or her particular data, they may only retain that data in a case if it is needed for specified purpose or any law of the land authorizes them to do so. Otherwise, that particular data has to be erased from the all consoles of the data fiduciary. Moving further, the third right is right of grievance redressal. Under this particular right, data fiduciary has to maintain a readily available grievance mechanism under which data principal can write to data fiduciary or a consent manager, whosoever he wishes to, for redressal of his or her any grievance. But under this particular grievance mechanism, that particular data principal has to exhaust their right to grievance, then only they can appeal or reach to the Data Protection Board of India. Otherwise, Data Protection Board of India may not entertain their grievance as the procedure is enumerated of this nature under this particular right. Moving further, the other right is right to nominate. Whenever a person due to any incapacity has been not able to write or give their consent or in any manner act according to the Data Protection Act of India, they may nominate another person who will on that particular data principal's behalf will take care of all the provisions and rights and duties pertaining to that particular data principal. These are the four rights which have been given to the data principal as of now. Moving further, there are certain duties which a data principal has to adhere. And the very first one is that they have to comply with laws of land. They cannot deny and they cannot act beyond the laws of the land. And while performing their whole functions under this particular act, they have to comply with the laws of the land. Second is that they should not impersonate for being another person while they are giving their data to the data fiduciary. This is their responsibility and the onus is on them that they are the same person what they are claiming to be. And they cannot impersonate in any manner. Further, they cannot suppress the material information which they have to submit with the data fiduciary while they are availing their goods and services which data fiduciary is offering to them. If any they have suppressed any material information, then the onus is on them if anything goes wrong. Just because of that particular information submitted by the data principal to the data fiduciary. Moving further, whenever there is any grievance which is being registered by the data principal with the data fiduciary or consent manager or Data Protection Board of the India, it is their duty of utmost importance that they shall never file or register any false or frivolous grievance or complaint with any of the authorities so mentioned. Last duty for the data principal is to furnish information verifiably authentic while they are exercising the right to correction or erasure. If they are exercising their right that their data is to be corrected, updated, or is to be completed or erased, it is their duty that they will provide the information in a manner which is intact, concise, precise, and is directly related to that particular subject which is to be updated, corrected, erased, or authenticated. So these are the particular rights and duties which have been enumerated under DPDP Act 2023 pertaining to data principal. Moving further, now a Data Protection Board of India is to be established by the central government, which is yet to be notified, and we are eagerly waiting that as soon they are going to be enacting the same. Now, what Data Protection Board is? Data Protection Board is a body corporate, and they will have a perpetual succession. It will have a perpetual succession and a common seal. and it can enter into a contract, and the board can be sued, and board can also sue another party in their own name. As it is going to be enacted under the provision of this law, so it is also a statutory body, a body created by law. So there are certain functions and powers which has been enumerated to the Data Protection Board. Some of them are that they can inquire into the data breach and impose penalty if any complaint has been received by them, or they can also inquire into any particular data fiduciary organization on their own if they have the suspicion that particular data fiduciary is not adhering to the provisions of this DPDP Act. They can also inquire into the breach and observance by the consent manager. Now, consent manager standards and rules are going to be prescribed by the central government, under which they will surely maintain this, that how and on what grounds consent manager is going to act and what all roles and responsibilities a consent manager has to adhere. If Data Protection Board gets to know that consent manager is not adhering to all of them, then the board can inquire into that and accordingly impose penalty on the consent manager itself. And moving further, if moving further to the another right, if a Data Protection Board gets to know that any data principal has filed a frivolous and false complaint with the Data Protection Board or with the data fiduciary or consent manager, then they can be also levied with a penalty. And this is also one of the functions and power of the Data Protection Board. Further, Data Protection Board has been enumerated with this right also, that they can always direct any kind of direction which is necessary for the compliance of this act. After noting that in a reasonable manner, in a writing, that why they are giving such direction to any person for compliance of this act. Further, they have also this power that they can modify, suspend, withdraw, or cancel any of the direction which has been imposed by the Data Protection Board earlier. And accordingly, that particular modification, suspension, withdrawal will be applicable on any of the direction which they have already passed. Further, they have this power also, that if they believe that parties can redress their grievance and whatever dispute is between them for the alternate dispute redressal also. And lastly, they have this right also, that they can take an voluntary undertaking from any of the person for the compliance of this act, under which a person will clearly define that what all they are going to adhere and what all they are not going to adhere in accordance to the provisions of the DPDP Act. And if anyone is found to be in violation of this voluntary undertaking, then they can inquire into that particular situation and accordingly fine them. Moving further, please. Now, there are certain special provisions which has been enacted under this particular act. The first one is pertaining to the cross-border transfer. Now, there is a restriction which has been imposed by the central government, and a list of certain countries or the other nations will be following up in certain days, wherein data cannot be processed of a individual or a person of this nation who has given consent for the processing of their data by a data fiduciary who is providing services and goods within the territory of the India. So this is one which is to be notified recently, and we are looking forward to it. Moving further, the other section, please. The other section is pertaining to exemptions. This also falls within the special provisions of the Act. Section 17 of the DPDP Act has enumerated certain exemptions under which, without consent, data of a data principal can be processed. And the further and firstmost is that a legal right or claim. If there is any legal right or claim of any person pertaining to the data which has been submitted by a data principal to the data fiduciary, then that particular in that particular situation, you may not take consent from the data principal to process that particular data. If Second exemption is that if there any court, tribunal, or any other body which has been provided with the powers to provide certain judicial or quasi-judicial functions, can always pass an order under which, though no consent is needed from the data principal for processing of their particular data. Further, if there is any need in the nation for prevention, detection, investigation, and prosecution of any offense or contravention of law, then LEA, legal enforcement agencies, can always process their particular data without taking the consent of the data principal. Further, if there is any merger, acquisition, transfer, amalgamation of companies approved by court or body authorized to do so, then also there is no need of taking consent from the data principal while doing all these activities as enumerated under the section 17 of the Act. Further, if the personal data of a data principal is not processed within India pursuant to a contract with a person outside the territory. Now, this is somewhat you have to take note of, because to the best of my knowledge and understanding, what I could interpret is that if any entity which is processing the data of a person who is not resident or citizen of India, but under a contract, they have been provided with this right that they can process their data, then that particular data is exempted, processing of that data is exempted from this Act. Moving further, for ascertaining financial information of a loan defaulter. If a person has taken any loan from the bank or any advance from the financial institution, then that particular bank or that financial institution can always process to know and ascertain their financial information, but according to the laws of land which are applicable to the banking system and financial institutions, they can process their data without taking consent of that particular defaulter. And there are certain more exemptions which are not directly enumerated, but for purpose of there are certain obligation on the data fiduciary that they have to maintain reasonable security, and they have to, while they are transferring any data from one entity to another entity, means one data fiduciary is transferring to another data fiduciary a data given by a data principal, and if they are processing any data which is directly affecting and is concerned to the data principal, data fiduciary has to maintain accuracy of that particular data. For this both purposes, central government can, by notification, declare certain class of data fiduciaries and data fiduciaries from to be exempted from these particular provisions. And this is all about the exemptions as of now. Now, there are certain miscellaneous provisions which talk about the protection of action taken in good faith. This is pertaining to the central government or any state instrumentality or any officer or member under this particular act so embodied that if they have taken any action in good faith for the compliance of this act, then no particular dispute can be arisen against them. Further moving, power to call for information. Now, central government has been empowered under this act that they can call for any information from the Data Protection Board of India for taking measures and making it compliant to the Data Protection Act of the India. Further, there is also certain powers with the central government to issue directions to intermediaries and other data fiduciaries to block a particular good or service in India if they are not complying to the Data Protection Act of India. And for that purpose, if they are not adhering to the directions of the central government, then central government can write to Data Protection Board for taking a necessary action for the breach. Further, there is also consistency with other laws. Particular, this act says that it is not beyond any law. This is in consistency with other laws of the land. And in case there is any dispute between any other law or between DPDP Act, then to that particular dispute, DPDP Act will be in prevalence. Further, bar of jurisdiction. This particular act has barred jurisdiction of the civil court from entertaining any dispute, as Data Protection Board has been enumerated with the powers of civil court under this particular act, and for that purpose they can investigate, they can take summons, they can issue summons, they can take evidence on record, and central government may also prescribe certain rules and regulations and standards for the board in adherence to this CPC, that what all powers of the civil court board will have. So no civil court can ever entertain any matter, any dispute related to Data Protection Act. Further, power to make rules. Now we have been discussing now and again that central government will issue rules, central government will prescribe rules. So this particular section 40 of the act provides power to the central government that they can prescribe rules for the better functioning and adherence of this act throughout the territory of India. Moving further, penalties. Now, Data Protection Act has given certain penalties which Data Protection Board of India can impose if a person is found to be in breach of any of the obligations and provisions, rights as enumerated in the Data Protection Act. While imposing such penalty, the board will take care and will always take into consideration that what is the volume and nature of the breach of that particular data, what impact will be on the person to whom that penalty is going to be imposed, and how many times the particular incident has repeated, and principle of natural justice will be adhered. And if the main component, which is very important for the integrators and for the data fiduciaries, Data Protection Board will always take into consideration that if what all measures has been taken by the data fiduciary, significant data fiduciary, consent manager, the person who has given voluntary undertaking for in adherence of this particular act, so that how they have mitigated the risk. If so, this is the very important and significant point which we should always keep in our mind, that we should adhere to all of the provisions of this act and try to make it intact in accordance with the act only. So if anyone is found to be guilty of any breach, then the board has power to issue penalties up to 250 crores in a matter where the reasonable security safeguard has not been adhered by the data fiduciary. Section 8 of the act provides that there is an obligation of the data fiduciary to maintain reasonable security safeguards for preventing any data breach, loss, or any kind of harm to the data. If any data fiduciary is found to be in breach of this particular provision, then up to rupees 250 crores fine can be imposed upon that particular data fiduciary. Next one is failure to provide breach notification. Now there is an obligation on data fiduciary that whenever there is a breach of any kind of loss or any misuse of the data, that data fiduciary has to inform the affected data principal and the board of the India, Data Protection Board of India, that a particular breach has taken place and it has been now taken care and it has been brought to our consideration. If any data fiduciary fails to do so, then they can be imposed up to rupees 200 crores, fine up to rupees 200 crores. Further, children data, failure to comply with additional obligations. As we have discussed in deep about the obligations of data fiduciary pertaining to processing of the data which is regarding a child. If any of the data fiduciary fails to do so, then they can be Data Protection Board of India can impose fine up to rupees 200 crore rupees on that particular data fiduciary. Now, significant data fiduciary fails to adhere to the additional obligations as enumerated under the DPDP Act, that there shall be a data protection officer, that data protection impact assessment has to be done, they have to appoint an additional auditor, and an periodic audit is being done, is to be ensured by the significant data fiduciary. If any of these particular conditions of this particular act has been breached by the significant data fiduciary and it is proved that they have failed to do so, then up to rupees 150 crore fine can be imposed by Data Protection Board of India upon that particular data fiduciary. Now, breach of other provisions. Now, there are a number of provisions, and this breach of provision is applied to all of the ecosystem partners which are being the party under this particular act. If any of the provision of this act is being breached and it is proved that they are guilty of that particular breach, then up to rupees 50 crore fine can be imposed by Data Protection Board of India on that particular individual or data fiduciary. Moving further, breach in observance of the duties by data fiduciary. Now, this is very unique that if a data fiduciary is not adhering to the duties as enumerated under the DPDP Act, which we have just discussed, that they will always take care that all the data information provided by them are accurate. They are not impersonating to another person. They are not filing any frivolous or false complaint with the data fiduciary and the board and the consent manager, and while they are giving the accurate information to the data fiduciary for any update, accuracy, and erasure of their particular data. If data fiduciary is found to be guilty of that particular breach of their duty, then they can be fined up to rupees 10,000. Further moving, if any person has given voluntary undertaking to the board that I will be adhering to the principles as enumerated under this act, the provisions enumerated under this act, or I will be abstaining myself from doing particular thing, estoppel has been invoked by that particular undertaking, and that particular person fails to do so, then board can, if a particular undertaking is in regard of that, I will be adhering to a particular obligation, and that obligation falls under rupees 250 crore fine. Then the board can invoke that particular provision and fine that particular person according to the obligation which he or she is in breach. So this is all about the Data Protection Act, and we would be open for the questions further. Thank you.
Just give us 1 minute, please.
Hi everyone. I understand that today's presentation was purely of a legal nature, so I hope that everyone is on the same page in the level of understanding of the Act. As my colleague had refreshed about the pointers that we discussed yesterday, I hope that after the session you had some clarity regarding your aspects and your roles and duties as a data fiduciary. If not, we are open for all questions today again as well. Kind of refreshing what we went through today. We talked about the rights and duties of a data principal, something which is very unique to this Act, wherein the onus is not only on the data fiduciaries or the data processors, but also on the data principal to ensure that they are also not in violation of any Act. Again, there's no need to be concerned about your role as a data principal as well. The roles and duties are pretty general in nature. Apart from that, we spoke about the Data Protection Board of India, which is going to be the regulatory authority concerning aspects pertaining to the Act. There we spoke about certain special provisions and certain exemptions which are laid down under the Act. A lot of questions were raised yesterday regarding exemptions from the Act. We spoke about the roles and duties when we speak about archiving data or using data for statistical purposes by anonymizing it or for research purposes. So we would love to take up questions on the same today again. Apart from that, we spoke about several miscellaneous provisions as well, which are laid down in the Act. And we spoke about penalties as well. At the first reading, you would find that the total amount which has been laid down under the Act is a lot. However, it is really important considering the nature of data that is being processed in our country in the present day, especially because all of us are concerned with health data. We need to ensure that we comply with all the provisions under the Act. Otherwise, the penalties which will be imposed will actually be a lot on all of us. And yeah, so that is it. Also, if you go through the penalties part, we saw that there is a specific penalty laid down on breach in observance of the duties by data fiduciary, which is up to 10,000. So we feel that that is a leverage that has still been given to data fiduciaries, as you know, this is a new act. All of us are trying our way to get around and understand our roles and responsibilities as fiduciaries. So even if there are situations when a breach has been observed, the penalty is still kind of reasonable, which is up to 10,000 at the first instance. So that is kind of a blessing in disguise for all of us. And my colleague would like to add on something.
So basically, very important aspect was left by me while we were discussing exemptions. It is pertaining to the central government and state instrumentalities. They are also exempted under this particular act. If the central government, in the interest of sovereignty, integrity, and friendly relationship with other state, and for the maintaining public order, and for the prevention of any offense pertaining to all of them, has defined that processing can be done. And further, if any processing is being done for research, statistical, or archival purpose, which is not directly affecting the data principle, then all of that processing is also exempted under the Act, under Section 70. So at that time, when I was discussing exemption, by mistake it was left by me. So I just wanted to make it clear that there is also provision pertaining to this. And further, central government is also having this power that within 5 years of functioning of this act from the date of enforcement, they can exempt any class of data fiduciary or data fiduciary from certain provisions of this act. So looking forward to it, that what central government is going to make rules in that particular regard. Thank you.
So we'll just take questions now. So Dr. Umesh, could you please unmute yourself?
Sir, sir, actually there was a mention reasonable security taken, and what
Sorry,
that
Dr.
actually
Umesh, we're
means,
not able to hear you.
breach. Can you hear me, sir? Hello? Hello?
Just give us a second, Dr. Umesh. I think there's something.
Hello?
Just give us a minute, please.
Hello? Hello, hello. Hello, hello, hello. Hello, hello. Hello, hello.
Dr. Umesh?
Yes, sir. Okay, sir. Actually, there was a mention.
Actually, your voice is very low. Can you please raise your volume?
Yes, hold on. Is it okay, sir? Hello? Hello, can you hear me, sir? Hello? Hello? Hello?
We can
Hello?
hear you. I can hear you.
Okay, sir.
Just a second, Dr. Umesh, just a second, please.
Hello?
Dr. Ramesh, could you please unmute yourself now?
Yes, sir. Can you hear me, sir?
Yes,
yes,
perfect.
perfectly.
Okay. Now, so I wanted to know what is that minimal reasonable security measures as a data processor has to take in, sir? Like, do you mean that all the milestones people, ABDM people have taken a VASA certificate? Is it sufficient, or you want us to do something more than that? And if it was some password leak and some accident happened before that, or if there was some attack by the virus and all that, so is it what will the impact in terms of data breach to honor?
Dr. Umesh, it is totally up to you that what all measures as per the industry standards and best practices worldwide is being taken care for making the reasonable security measures applicable. So, like you have taken VASA, that is very good. And am I audible?
Whoever is not asking questions, please mute yourself. Thank you.
Hello? Yes, sir.
Dr. Umesh?
Yes, sir. So, the VASA certificate, yes, sir. Go ahead.
So, not only VASA, what all best industry practices are there?
Apart from VASA certificate, all is expected from yes, sir. Because all the ABDM compliant softwares will take that, sir. Anyway, otherwise they
Yes,
won't
you
get
have to take that. You
milestones.
have to take that. And in addition to that, what all particular measures for the safety of that data you can take into consideration, you have to.
Will any all these people, like for vendors, will they give government give us some prescription? Minimally, you have to follow these things, like apart from VASA, because something is given, it becomes easy to follow, rather than putting it very vague, and people may not be able to follow it. They should know minimally you have to do this like that. Will there be some guidance from the?
This, and you have to adhere to the industry best practices worldwide adopted by the similar organizations while protecting the data within their domain. Okay, sir. So it is up to you that how you are going to prove the Data Protection Board of India that I have taken all reasonable security measures to protect the data within my control, and while it was given to a data processor for the processing, and the same protocols were adhered by the processor also, and you should adhere to the best industry practices which is being adopted worldwide by the similar organizations for protecting their data as of now. And if government comes up with certain norms pertaining to this, then it will be very good for us to adhere them. As of now, we don't have.
Okay. Thank you, sir.
Okay. Can we have Gopa Kumar? Can you please unmute yourself and ask your question?
Hi. It's yesterday we have raised a query regarding the concern when where we have a facility where the family members can be added. Now, for example, I can add my family members to have the services. Here in this case, how the concern matters? Do the concern matters?
Hi. So yes, I think a similar question was raised yesterday as well.
Yeah,
So
that remains unanswered.
Yeah. So the thing is that if you have to add your family members, then yes, under this act, as long as your family member is above the age of 18, you will have to seek consent of them. And otherwise, if they are under the age of 18 and if you fall under the category of parent or a lawful guardian, then you can give consent on their behalf in such circumstances.
Yeah. Okay. Thanks for the info. And now one more query which need to be checked with you.
Yes.
Some of the services which has been like outsourced services now as a fiduciary where the call centers will be the processors. In this case, how this will be impacting, and some of the services when is through the call centers. What the necessary steps and the precautionary methods has to be taken as a fiduciary.
So as we explained yesterday also, that data fiduciary and data processor will have a contractual relationship. So, but it is the onus lies on the data fiduciary to ensure all such reasonable practice are put into place. So, as a data fiduciary, whatever work you're outsourcing to the data processor, you'll have to make sure they abide by all the rules and regulations that are set under this act. And if there's anything, I think the data fiduciary would be held liable for that by the Data Protection Board. So I think to have a good contract in place with the data processor would be of utmost importance over here.
Okay. Okay, thank you.
Thank you. Can we have Sandeep Thote to please unmute yourself and ask a question?
Hi, thanks, NHA team. I have few questions. First one would be like we talked about the data principle can raise for the erasing of data. However, from medical and there are legal rules to keep the data 5 years, 7 years, or 18 years also in case of the ANC and childbirth. So how would the fiduciary should retain the data also and also comply with the request of erasing the data?
So Sandeep ji, as my colleague Ashka has also explained this yesterday, and today we have discussed deeply about erasure. It is that data fiduciary will not erase that particular data if it is needed for a specified purpose or it is to be retained under any law of the land. If any law of the land is saying that a particular data, medical record, you have to maintain for a particular limit, for that particular limit, you can straight away tell to the data principal that as per the particular law, I have to maintain and retain this record till this particular time. And for the specified purpose, while you have given the notice to them, you will ensure and inform them that your data will be used for this specified purpose. And now, if a data principal has made a request for the erasure of that particular data, you can simply make him understand that the data which was collected from you was for this specified purpose, and this specified purpose has not yet been achieved. But there is also a clause which says that if anyone has withdrawn their consent, any data principal has withdrawn their consent, then you have to immediately act upon it, and then further processing has to be quit. So if anyone has asked you to erase their data, then you will only process the data till the time such request was not made to you. So this is the situation in the DPDP Act at the current time.
Also, just to add, as discussed, so the thing is that the Act has also mentioned that there will be prospective rules on retention. I understand from a medical perspective, this is one of the most concerning aspects regarding erasure of the data. So hopefully there might be some sector specific guidelines that might come out while dealing with retention of data. So all of us are also in discussion that, there needs to be a sector specific thing for medical data as well, so that we have the liberty to, because if you logically think, practically the purpose of someone's health is throughout the course of their lifetime. So there might be a situation where the data, there's no need to even erase the data, because if you're treating someone for a chronic disease, then the data needs to be stored for a longer period of time. So hopefully MIT covers the same whenever they come out with prospective rules. So we just have to kind of be patient and wait for their perspective on the same. So I hope that answers your question.
Yes, thanks for the clarification.
And there is something more to it also. I just recalled it, that central government has this power to exempt certain data fiduciaries and class of data fiduciaries from the right of exercising erasure, as we have just discussed in under the exemption also. So looking forward to it, that what all classes and what data fiduciary they might exempt from the erasure particular this particular provision.
Thank you for clarification.
Thank you. Thank
I
you.
have
Can we
one
have,
more question if I can ask.
so please go ahead.
Yeah. So if you would like see that most of the fiduciary we interact is more the clinics, hospitals and stuff, they would the hardly have the knowledge or technical nitty-gritties of how the data protection, how to protect data and all aspect. How would is there some kind of guidelines or we can share with them that by having the ABDM compliance system, at least this thing is there are 1 2 3 4 are covered from the data protection. Of course we cannot cover everything, but at least we can say this part is covered by having the ABDM compliance, HMIS or their clinic management system.
See, firstly, what I would like to tell you is no matter how small or big an organization is, we cannot plead ignorance of law when the law is already in place. Secondly, I do understand that there's a gap between the understanding of an act. So what we've done is we have our presentation. You can basically take pointers from that and take, because they're quite in a layman language, and the act itself is quite simple to read through. But you can definitely take this presentation and share, just guide the fiduciaries or any processes which you have. And it's we have our team has actually jotted down all the rights, duties, and obligations quite clearly. So maybe you can use that for any educational purposes. But otherwise, from that, I think we cannot plead ignorance of law, is what I feel.
Sure. No, we appreciate it because we do participate in medical conferences, so we can kind of cover up on this aspect by having using the presentation that you have.
Sure. Thank you so much. Dr. Pankaj, can you please unmute yourself and ask a question?
Yeah, good morning, everyone. So my question is related to the audit part. So like earlier, VASA, there were like 125 companies who used to do the VASA certification to check the milestones. Currently in this act, which all organizations will be there, or like it will be done internally by the government of India, or how it will be done, that audit part?
So you have to appoint an external auditor also, and for the audits, and not only VASA, other like I have just explained before, that best industry practices for keeping the data secure. You have to adhere to them also.
So, as just in addition to that, if the central government, notifies the data fiduciary to be a significant data fiduciary, then there has to be as earlier stated by the team, there has to be an appointment of an independent data auditor to carry out the data audit. So that has to be kept in mind, because that's an additional obligation of a significant data fiduciary.
And what all will be the checkpoints to fulfill the requirement?
So for being a significant data fiduciary, as explained yesterday, the government will notify that based on the volume and the sensitivity of data which you're handling, and other things which were enumerated yesterday. So you have to see the potential impact on the sovereignty, on the integrity of India, or maybe the security of the state or any public order. So all these will be the benchmark for judging whether you're going to be a significant data fiduciary or a data fiduciary.
Okay, thank you.
All right, thank you, Pankaj. So if there are any more questions, we'll just wait for a minute. Otherwise, we can end the seminar.
When will the record uploaded, madam? The records, when we can have them on live on YouTube, or so that when you can expect them?
We'll just try doing this by today or latest by Monday.
Okay.
You can keep on checking the website because we won't be able to tell you guys that we have uploaded it. So please requesting the same, but we'll
No,
try to upload
will,
it.
will it be on YouTube only? Madam? That will be the best.
It'll be on
Sometimes you
YouTube
put-
as well as the ABDM website.
Oh, okay. Because sometimes it's put on the drive and we'll have to download it and so that's
No. So we'll be putting it on the website as well as YouTube. So,
okay. Sir.
and if there's any other question, there was an email shared yesterday in chat. I'll be just sharing that in the chat again. So you can just mail your queries on that email. All right. Thank you, everyone.
Thank you.
Thank you, NHA team. I appreciate it.
So much.
Thank you.
Thank you.
Thank you.